The same is true from the plaintiff side, Floyd. If they do
Exactly.
testing and
If
don't
they
find
test and they have clean water, they
and
have
don't
to
find
do-
anything,
What did
that
I
helps
do?
us.
What did I do the moment we found vanadium? I told
Well-
you about it, okay? I told you about it. I didn't play hide the ball. I tried to move things forward.
Okay, let's, for those of you on the Zoom, can you hear me okay? You're all muted, but just nod if you can hear me okay. All right. Let me go over a couple of things. Like I said, I was going to give Will Kemp the award for the latest production for today, but I got one at 11:30, so it was just old letters anyway. Let me ask you about this. Is this CMO that was provided to me agreed to? I looked through it, but I didn't know, is there a dispute on it?
It's a defense proposal.
Was it routed to everybody? I just got it this morning.
It just got started.
All right, well, it's pretty standard. Would the defense take a look at this and either a group of you together or whoever wants to respond? If the defense wants to coordinate the response, just email me back with what you want. And we can probably take care of this through emails or something. We don't have to have a meeting, so. Mr. Federico, can you hear me okay?
Yes, sir.
I just want you to know, everybody on the gallery, you're the one that's on the huge screen right now.
Oh, is that right? So should I get off it, or is it okay? Is the judge going to show up and be looking for me with no tie today?
No dress code.
All
You know,
right,
we started
all right.
these special masterings in Judge Earl's chambers downtown, and, he's very strict. And he would walk into the conference room and if somebody didn't have a tie on, he made them go home. And I said, they're on roofs and stuff in the morning. But no, I don't have a dress code. So
All right.
right,
Otherwise,
well, on
I'll
the
switch out. I'll
CMO
switch out.
if the defense can kind of give me their response, there's no real deadline on this.
Plaintiff.
I'm sorry, the plaintiffs can give me their response. If you do it in group, then I'll probably get everybody on a conference call or something to resolve anything that,
The first big problem is in the Gallagher case, we have a motion for expedited trial that Judge Williams is going to hear on November 30th. And
which one?
Gallagher.
Gallagher.
So assuming he gives us the expedited trial, and that'll probably take some time, basically, April or May next year. And this has the close of discovery, 6 months after the start of the trial.
Just to be clear, this one's only for Henwardson. There'd be other ones for like Gallagher.
And Gallagher's down here is listed as,
The one I have,
Yeah, it's only intended to be for the Henwardson case.
yeah,
for which one?
Hanwardson.
that's one Judge,
There'll be
Mr. said,
different dates for different cases.
okay. Well, how are we going to do that with the other cases then?
Just do a separate order with the dates, so everybody will know what the dates are.
Is Hanwardson, which one, is Hanwardson a death case?
No.
Is that the liver transplant?
Okay, yeah.
What was the death case?
The death case is in the Gallagher case.
That's Gallagher, is that the one going to trial? Is that- And when are you going?
We filed the motion, and we
Okay.
don't have opposition yet. I assume there'd be opposition. But the hearing's November 30th.
Okay. All right, so I'll wait to hear from folks on that. And then on the other item, Will routed, it has a proposed agenda, which really is kind of a carryover of everything we had before. But he also attached his letters on discovery disputes, but I'm assuming we'll wait for responses on those.
Well, I mean, how long do I have to wait to get a meeting for? Like
Well, one
Milwaukee, we
of
sent
them you sent was October 31.
One of them we just sent, but the other one we sent a week ago on Monday. And
Yeah, I've got one October 24, one October 31. Do I have, how many do I have here? 3? October 24.
wait 2 or 3 days or even a week to have someone talk about it. But the status of that is we got an email yesterday saying someone's going to call us. No one called us. Some attorney's leaving and someone's coming, So
All right, well, I have a Hanna letter Milwaukee letter. And what's the third one? Is that the only two?
No, those are the only two.
Those are the only two?
All I'm saying, there's got to be some drop dead date that, they can't just jack around by not calling you back.
Well, Jason Wigg here
One
for
of them's
Hanna.
only-
I
only 3
apologize.
days ago.
Yeah, it was
Hang on
only,
now.
I've
Hang
been
on now.
buried, man. I've
It's
been
okay.
buried. I apologize, but hell, I just filed the answer in the case earlier this week. So, I mean, I was happy to answer the discovery because I knew, I was just kicking the can down the road by saying, hey, I haven't been.
Produce their insurance policies. They should produce those at the 16-1.
Well, I haven't had a 16.1 yet, and I haven't had a disclosure obligation in that case yet.
Which party hasn't had it? Milwaukee hadn't had it. Who do you
No,
represent?
Hanna in the
Oh,
Henry,
Hanna
in the
Instruments?
Henry case. So the insurance policy is going to get disclosed.
Who's got Milwaukee?
Elizabeth
This is
Lowell.
Rob Robbins, Floyd.
Yeah,
sorry.
is the attorney from Milwaukee participating today?
Can you hear me, Floyd? This is Rob Robbins. Hello?
Yeah, Rob. Yeah,
sorry.
when can you respond to the October 24 letter?
Yeah, I'm just looking at it. Is that Will on the phone? I don't know who I'm talking to. on the
We're
other
in
side,
Zoom.
but,
Yeah, Will's actually here.
Okay. Yeah, I apologize. Liz Lowell from my office was handling that. She just gave notice, so I'm just now coming up to speed on it. I can give Will a call on it Monday, and we can try and work something out.
All right, we'll get back to him, and then when you two are at it, if you don't reach an agreement, give me your response and I'll rule on it.
Okay.
All right.
Can we have a deadline for the response?
Well, I was hoping you two'd work that one out. Yeah. how
Yeah,
about,
can we have a meet and confer before we start worrying about deadlines for responses? Let's see if we can work it out.
Well, I give these people, I think I give Hanna a 3-month extension of time, and then they file responses and don't even have the insurance policy.
It wasn't 3 months. I appreciate the extensions of time, but
Whatever.
you and I
All
can
right,
chat and we'll see if we can get it resolved.
On the October 24 letter, which is that's Milwaukee. Let me have a response by November 16. And then on Hanna, that was just this week, so we're running into Thanksgiving though. How about November 22?
Well, I'll give Will a call tonight or tomorrow, and we'll talk and see if we can't figure out, what we need to do to address the issues and see if we can resolve it. If we resolve it, what kind of response are you looking for?
None.
Okay, that's what I thought. Thanks.
Yeah, I very seldom rule on one that has no issues left.
Right.
So, no, yeah, and if you guys are still working on something and your response to, just let me know.
Okay.
You're not old enough to remember that date, are you? It was Kennedy assassination.
Thought that was the 23rd.
No, November 22, 1963, wasn't it?
Yeah.
That was the Pearl Harbor dates our generation. All right, so let's talk about, the other thing I want to talk about is the testing protocols. And I couldn't really tell from last catch up on this whether yes, there is an agreement or there's not an agreement on this testing. Let me get to the paragraph of the issue.
So Floyd, this is Jim Neale for UNFI and Whole Foods. We briefed the testing protocol issue. It essentially boiled down to one disagreement, and that was whether or not the parties could conduct work product testing on the extra water, the water that was to be disposed. You raised that issue at the last hearing, and my understanding was that you said work product testing is fine. You can do it on that water, but you have to tell people you've done it, and you have to preserve a sample of that water.
Yeah, that's already in order.
Well, that part isn't in order, but the rest of the protocol is not. So what we've done here is taken the protocol that we agreed on and added those two things to it. So this version should reflect the entire protocol in one place. And I think all of the parties want that in an order so that they can either take it up on appeal if they feel aggrieved. I'm not sure anybody does, or at least know where the answer is if they're looking for how to test.
So here's what I couldn't tell. On the exhibit that I have, it's 1D to Kemp's production, paragraph 4. Are you up with me?
Yeah, paragraph 4, the red lines there, Floyd, just represent my attempt to include the language from your order into the protocol that we had already negotiated.
Well, yeah, my feeling was that if you do testing, somehow that sample there has to be unaltered, identical samples so that if that comes out at any point, that they can double test it.
So this obligates the testing party to preserve a sample of the same. I think that's exactly what this does.
I think that was your order.
Yeah, but
No, it was.
Here's the problem I see. I don't know what this means, this first sentence. Any test may be relied upon by a testifying expert in those cases to the extent these results are disclosed in accordance with the rules. Okay, so they do secret testing. Don't tell anyone about it.
Well, that's 3A.
No, Will. Eric understands it. We've been over this a dozen times. He can explain it to you.
4 is the one that's utilized in the expert report under 161A2.
When do we get the test results?
So Floyd,
When do we get the so-called
this
work
is
product test results?
this is really simple, and Eric understands this very well because we've talked about it at great length for a number of months.
Okay, well, I'm
The
stupid,
testing
so explain it to
protocol,
me.
Me too.
the testing protocol obligates, if you're going to bring a test into court, that those results have to be shared well in advance. Eric understands this. We understand that was all negotiated and agreed to.
But what does well in advance mean? Does that mean the day before the expert?
It's all
report?
spelled out. Will, you have to read the protocol. It's all spelled out in here.
Why don't you just tell me the days then, if it's, you know what well in advance is?
All right, Will. So if you turn to paragraph,
If you're doing a disclosed test, first of all, you have to give everybody notice of the test.
that's
And
right.
They have an opportunity, and either way, you've got to preserve whatever you test to have identical marked samples. And you have to give people notice to participate and watch the test. And then, and I know there's deadlines for objections, and they're not really that long, the deadlines for objections. But what I don't remember is, when do you produce the analysis of those tests? Is it just when you do your expert report?
No, paragraph 9 makes it really clear.
That's what
It's
I'm looking at. 15 days?
15 days after you get them.
Yeah, that's been agreed to. That's not really in dispute. There's a protocol for that.
No, that's what I said.
This paragraph 4, where the changes are made, it references back to two subparagraphs 3. A is any water or other potential evidence from municipal sources or bottled water, not real water. So we didn't really discuss this, but I don't see that being a major issue if they want to test, some different water, bottled water. I mean, I don't know that that's a big deal. The only one that's in dispute is 3B, which is the secret testing on real water samples, that they basically say, we have this water, we're going to destroy it. After they say they're going to destroy it, they want to do secret testing on it, for whatever purposes they want. That was discussed as, we raised our concerns that, why should there be this secret testing without any ability to know if they find something in the water?
They don't find something.
Yeah, or they don't find something. And what you definitely said, well, if it's going to happen, they got to preserve half the sample for the other part.
Yeah, that part's not disputed.
Yeah.
It's what do we do with what they test, or the results of their testing.
Yeah, and so there's just some confusion with this. I think we need at least some further guidance and details in this protocol, because how do we know, they're just preserving the water, half the water sample, and they give it to us, they keep it. How do they track it with what tests that they've done. I think last time when we were discussing this, you said they have to preserve the documents related to the testing. But there's just.
And the chain of custody and the identification of the test results compared to the defense and plaintiff's sample.
Yeah, and I think, that would be fine as long as those details are spelled out. And I mean, the whole point of this is if they find something in the water, they should at least have some obligation to say, hey, this is the water sample we tested. This is what we found or didn't find.
So Floyd, we briefed this at length. You read briefs on this and you've ruled. This is not secret testing. This is called.
I have not finally ruled on the quote secret testing.
So this is
what I ruled on. Well, just a minute. What I ruled on was the preservation of the evidence. I'm not still convinced, based on the cell phone case, the cell phone screen case, and the other cases that were cited to me, that it's work product when an expert does a qualitative or quantitative analysis on a sample of water.
All right, so then,
having had a degree in chemistry, and now a degree in law, I have a hard time seeing, the one seems to apply to my undergraduate degree, not lawyer work product, rather than lawyer work product.
So Floyd, what I'd ask you to do then is look back at those briefs and make
I
a
remember
ruling.
you talked about the cell phone screen testing and the other, the two, there are really two main cases.
There's a lot of cases. There's no more than two, Floyd, and they all say the
but
same
there are really
thing.
only two main cases on this issue.
Floyd, they all say the same thing. They say if it's evidence in court, you're not allowed to do secret destructive testing on it. And they all say the converse of that, which is if it's not evidence in court, the work product rule.
Well, they talk about the complication of a cell phone being more related to work product because of what you're determining to do to the cell phone, as opposed to doing a chemical analysis of water.
Floyd, our experts need to be able to do work product testing. You can't strip all these parties and all these experts of the right to do work product testing. If you're going to do that, I'd ask you to put it in an order so that we can take it up. But
Okay,
one way or another.
If they're running not like doing the analysis of a cell phone, which they've talked about the complicated, that there's actually work product in determining what you're going to do. So
Floyd,
you're not going to win if you don't let me finish. So they talk about you actually have to use an expert to reach a lot of determinations on that. But if you're running a chemical analysis of water,
yep,
right? You run the chemical analysis.
Right.
What's the purpose to prevent you? What's the basis to prevent you from providing the results?
Because, Floyd, the decision to do chemical versus biological versus viral versus metals versus other things is exactly what that work product is. We don't know who to retain and we don't know what tests to run, and we need experts to tell us that. Nobody here, not the plaintiffs, not the FDA, not the CDC, has identified a causative agent. We're all looking for that needle in a haystack, Floyd. We all need the experts' input and free thinking to decide what tests to do on this water and how to do them. If you deprive us of the ability to that, nobody's ever going to find that needle because we're not going to know where to look.
So you find the needle and you get to keep it secret?
And nobody gets to keep anything secret that they're going to ever use in court.
Yeah, if you're going to use it.
If you're going to use it,
They
that's
can't
right.
use it if they're not giving notice and disclosing what the tests are.
Look, nobody can possibly be prejudiced by something that's not used. This is
Well,
like,
sure they can. Wait a minute. You might find some active ingredient that has a harmful effect, and you don't tell it to the plaintiffs, but you know about it, and you say, well, that's all part of our work product, and you don't think that's harmful to the adverse party?
well, first of all, Floyd, I don't think any of us are going to be looking for an active ingredient. We're all looking to find the absence of that in our water, not to find it.
So why would that be work product? You come out with an analysis that says there's nothing wrong with this water, but we don't want to tell you.
But no one's going to go into court and say that if they haven't shared the test results.
I don't get the privilege
Test results aren't
of doing a chemical analysis on a water sample.
I don't know what. Sorry, I
Test
interrupted you.
results are only secret if they're
You
positive.
ruled on this last time.
No, he didn't rule.
Look, we would like nothing better than to find the causative agent so that we can rule it out of our water.
No, I said they can't use any secret testing, but I'm still not convinced there should be secret testing.
Well,
If you're analyzing the water and you do a chemical analysis of the water, I mean, sophomores in college are doing this. I mean, it's not real complicated work product. You do an analysis of the water. It's not even your product. You do an analysis of wherever whoever distributed it or whatever, and you find what's in the water other than H2O, and that's privilege.
yes, the decision to do chemical analysis versus something else, and the decision about what assays to look for is absolutely work product, Floyd. And the decision about what tests to run to look for those is absolutely work product.
And you don't think the court's entitled to know what's in that water that you discovered?
I think the court's entitled to know, to understand all of the testing that comes into court. But experts are always entitled
That
to
wasn't my question.
and
The court wants
consultants.
to have all the facts, not just the facts you want to tell them.
Well, the court can have all the facts from the agency testing. The fact of the matter is nobody's yet found this thing.
Well, then what are you worried about producing the results?
Jeez. We need it, Floyd. We're going to need an
I know
order.
I'm new at this, but I'm not buying your argument. I don't understand if the court's entitled to full disclosure and you're required under 16.1 to provide full disclosure. When you find something in that water, a fact that you find something in that analysis, how are you exempt from 16.1 to produce it if it's relevant in this case?
Floyd, work product shields.
I want to know the answer to that question.
The answer is work product, Floyd. It's Rule 26.
The work product may be how you got there.
It's B3, 26B3. That's the answer.
All right.
Just like attorney-client privilege.
No, it's not like attorney-client. If you've got calcium in the water, that's not attorney-client privilege.
No.
If you got arsenic in the water, which I had in a mediation this week in a well, by the way.
The difference is the plaintiffs can do any testing they want. Their burden of proof. They can do any testing they want. There's nothing being destroyed. We're trying to preserve our rights under work product to evaluate.
But if you find something in the water,
but
how's that work product?
It's not only if we find something, if we don't find something.
Well, that's even better for, you're not going to hide that.
You made the determination.
Maybe we are. Maybe we don't want our experts cross-examined. Oh, you ran 300 tests and all of them were negative. What kind of expert are you? You're a defense whore because you ran 300 tests to find them all negative.
Find something in it.
In the last time you made the determination, when we went down through this argument, you basically said, okay, what I'm going to do is make sure that you have to preserve.
I know that, but that isn't the complicated
And then.
part. I get all
and
that.
Let it be known.
No, but I didn't
But
say,
it is
and
work
that's,
product.
So you find
No.
the needle in the haystack and you.
no, what I said was, I want it preserved so that the other side can run the same test.
And they have
that comes up
and they have
against
the
it.
right to
Yeah.
do that because of the fact that we.
I don't
say-
understand under 16.1, you have an obligation to disclose all relevant facts to the court. This isn't work product. If you're obligated to disclose all relevant facts to the court under 16.1, right? So if you find an analysis of that water and you find something in there, how is that is relevant? How is that not required to be disclosed to the court?
So if we find something there that's not relevant, are we still required to disclose?
What are you
that
going to
the
find
court
is
as
not
well?
relevant?
Well, if there's nothing in the water and we make.
Then you disclose all there is H2O.
But we shouldn't have to disclose it based upon the fact it's work product. We made the determination of what we're going to do, who we're going to utilize to make those determinations, and we make the product available to them. They can run the same test. If we take this water and require to give them half of it, and we run a test.
You're not answering the other half of the question, though. Once you find a fact that's relevant to this case, whether you like it or not, you have an obligation to disclose it to the court.
So
right?
if we run a test that's not work product and it's not evidentiary, and we find there's nothing in the water, we have to disclose that to the court, and we have to disclose that to them when they have the same responsibility. So they're gonna take our experts and use them we're making the determination it's work product.
You're not answering my question. If you find, no, you're saying you don't like it. I said, if you find something in the water, and it's relevant, how do you have the ability not to disclose that to the court under 16.1?
My answer is this: if we don't find anything in the water, do we have the same responsibility? Because
What do you
it's
care?
relevant?
What do you care?
Because it's work product. We should have the availability to have our work product make the determinations.
I said, if you find something relevant, if you don't find something, it's not the same question. You're going to find water, you're going to find H2O, maybe you find a little, I don't know whether they're going to have fluoride in this water or not, but if you don't find anything, then you don't hit the 16.1 duty to reveal something that's relevant.
But it's more than 16.1. You have the ability under our discovery rules to get an expert opinion, and you can evaluate that expert opinion, and you can choose to use it or not use it. Just because you got that opinion doesn't now make it a 16.1 fact that has to be disclosed in the case.
It's not the opinion that's the fact.
But it is the opinion.
You can have an expert review all the MRIs and CATs, medical records and drug tests and everything else in the client that everybody has. The protection is that expert does not have to reveal that expert's opinion if you're not going to use him or her.
The opinion is, here are the tests that I did, and here's
No,
how I
the
did
facts are what's in the water. That's not an opinion.
Yeah, the facts are.
It's a fact. Is there, like I said, I actually had a well case I mediated this week with arsenic in it. But
Was it evidentiary? Use it?
they already
Floyd.
have. I was mediating.
That's what I mean.
Floyd, we need our experts to tell us what to look for and how to look for it. Those are opinions. We need to know whether we need to go to a chemist or a microbiologist or a metallurgist and ask them, in their opinion, what should we be looking for and how would we find it? That's what we're trying to protect. I'm not entitled to know what Will Kemp's experts think right now, nor is he entitled to know what our experts think right now. That's work product, and that's what we're trying to protect. If a test comes into court, it will be fully disclosed under this protocol. But if it's work product, it's not. All we're trying to do is to protect that deliberative process that every
I'm having
expert,
a hard time seeing
If you
how discovering the facts of what's in the real water product, once it's a chemical analysis. We're not talking about
who
a
says
medical expert interpreting CAT scans and MRIs and brain waves and things like that. We're talking about, is there calcium in the water? Is there arsenic in the water? That's a fact. That's an analysis and a fact. And that's what bothers me is I had to live under 16.1 and the rebuttal rules and everything else, which I never agreed with, but I have to live with it. And I have to enforce it now. How do you, if you find something in that water, how do you not disclose that as a relevant fact under 16.1?
You're skipping ahead to the conclusion, Floyd. And what we're trying to focus on is all the deliberation prior to that. Which experts do I retain? Which disciplines are they in? You're assuming chemistry. Nobody here has identified a chemical.
That's just one. No, that's just one.
But Floyd, my point is that that's one of endless numbers of possibilities. All we're trying to do is to protect that search, that expert deliberation.
I'm talking about protecting the result under 16.1 though.
All right,
That's
but what you're suggesting is that we, in advance of testing, disclose what disciplines are involved, what tests are going to be run, and what they're looking for.
Say that. Who's talking about that? Nobody
That's
mentioned
what
that. I said, no,
Floyd,
that's not what I said.
Floyd,
It's pretty simple what I said. If you find, whatever you find in the water analysis, however you found it, if it's relevant, how do you not disclose that under 16.1? That's what I'm asking. How do you not disclose once you know what's in the water under 16.1?
Floyd, work product protects that kind of thing every day in every case around them.
How can you stand up in a court of law after your expert tells you what the needle is in the haystack and say, oh, ladies and gentlemen of the jury, there's no problem with our water? How can you do that ethically?
You guys are assuming
from us.
Well, you're assuming
if you don't find anything, you don't find anything.
This is assuming all kinds of stuff that's not in evidence. Nobody's found anything yet. No, everybody's paralyzed and
I don't
can't
know
do
that
any.
you will. I don't know that you, all I'm saying is 16.1 paints with a pretty broad brush. And it says, if you have relevant facts, you have to disclose them, whether they help you or not.
16.1 doesn't invade work product, Floyd.
All right, I've got the briefing. Does anybody want to submit any other briefing on this?
5-page brief.
What was my last round of briefing on the cell phones, and what was the two main products in those cases?
We just
It's been a couple of months.
5-page additional brief by next week.
You had a briefing schedule before that.
Yeah, I
is
have a
long-
briefing.
Focused on the issue, the needle in the haystack issue.
No, he's got the work product issue in there.
And we did brief, that issue, that's our concern. All we're concerned is not, being unreasonable or not letting them do things or putting onerous notice requirements on them that are unreasonable. It's just protecting that instance is if they find something, how do we have assurances that we're gonna know what it is? And how are we gonna, be able to tie the sample that they're.
Well, I'm not so much concerned about your insurance. This is their duty under 16. You got to produce stuff that hurts you too. Once you have facts, you have to produce it under 16.1. I'm talking about facts.
This is something that you affirmatively go create. This is not a fact.
No, you don't create the calcium in the water. You don't create the arsenic in the
You
water.
select which sample we have, as you pointed out last time, more water than we could possibly drink. We go out. there and
Water
we-
everywhere, but you can't
You
drink.
said that last time. We're the ones who then, the burden is on us to go pick the samples. We go do that. And then we create this test result and you're saying.
No, you don't
"Yeah,
create,
we
yeah, you
Absolutely do. We
you
pick-
create the test
we
result,
use
but you don't
our
create the
experts
fact
to
of what's in the
pick
water.
Which one of these bottles are we gonna test? And then we tell that expert, okay, what test are we gonna do? And now you say, regardless of whatever it says, we have to turn that over.
I said,
You're punishing us for trying to do our due diligence and do an analysis as to what our liabilities may.
this
or
is
may not
why,
be.
this is why in the construction industry, the defense never does destructive testing. They don't want to find the bad stuff because you have to produce it.
Maybe not.
And in the medical field, whether you like it or not, if you've got a scan, it's got, and you have an opinion, that's a work product. But if you do testing on water and you find calcium or arsenic or fluoride or whatever's in the water, that's a fact.
But that fact is out there and they can
You
go.
will
get
have
it.
an expert who will
That
say,
fact is out there and they can go get it. The fact that so now the plaintiffs go, oh, well, Mr. Expert, you were hired by Mr. Odou, weren't you? And you found all these bad facts, didn't you? Oh, thanks, case over.
haven't you ever had your expert deposed before? That is what happens in an expert depot.
And who told you to do that testing? Oh, Mr. Odou told you to do that testing.
No, that's not the question. The
That's what
question
happened.
is there,
That's the
what
reality.
is in this water?
I've never had a
You can have medical experts say, that's so what, that didn't cause any problem.
I've
That's not-
never had a consulting expert deposed before, and I've never had a special master or a judge tell me that I couldn't hire a consulting expert. And that's
I didn't say
exactly,
you couldn't hire a
and
consulting.
that,
expert.
excuse me, Mr. Hale, that's exactly what the effect of what you're talking about would be. Everybody here wants to find out what the problem in the water is, and what you're doing would discourage anybody from testing because they don't know what the answers are. If we want to get to the truth, you ought to be encouraging as much.
What happens when you get to the
Excuse me,
truth?
Mr.
You're
Hale.
telling me it's work product and you're not going to produce it.
Excuse me, Mr. Hale, if you want to get to the truth, you ought to be encouraging as much work product testing as can possibly be done.
Why? You're not going to produce it.
Why do you assume that? If there's,
Well, you just said we won't test because we have to produce the results.
what I said was that people will have a disincentive to test if they have to share and they don't know what the results will be.
That's what 16.1 is all about.
Floyd, 16.1 does not invade or supersede the work product doctrine.
It requires a
16.1,
specific disclosure of all relevant facts.
it's not the facts we're trying to protect, Floyd. It's all the deliberation going up to it. It's decisions about which water to test, how to test it, what battery of tests to run, what disciplines of experts to use, how to conduct the tests, what detection limits to use, what assays to look for, what might possibly be toxic. You're trying, if you require us to disclose all of that, you're depriving us of the ability to look for the problem here.
But what happens if you find the problem? You're telling me, well, that's work product. We're not going to tell anybody.
If we find the problem, we're going to do our best to make sure it's not in our water. There's about 7 or 8 different channels of
But you're not going to
distribution.
reveal it in this case.
We can't, if we're definitely going to, if we find the problem, we want to say, hey, it's over there and not over here. We'll do testing under the protocol that requires disclosure.
Hey, your attorney can bring this out on redirect. I'm cross-examining you. And when you find that problem, because you don't want me to deter you from testing, but when you find that problem, you're not going to reveal it in discovery.
If we find that problem in our own water, Floyd, if we would have an obligation, if it's going to come into evidence, if that testing is going to come into evidence.
Suppose you don't want it in evidence. Once you find the problem, you're saying you don't have a duty under 16.1 to produce it.
So, Floyd, you don't think that
You're
when
not
an
answering my question.
I am.
Do you believe
Floyd.
you have a duty if you find something wrong with that water, regardless of how your expert found it, you find something that somebody may argue is harmful, do you feel you have a duty to produce that under 16.1? Yes or no?
No, Floyd. Consultants do testing all of the time that illustrates potential problems with products, and they're non-testifying consultants, and it's not admissible in evidence, and it's not used against
Their
anybody.
opinions aren't admissible.
No,
What's in
Floyd.
a
No,
water
Floyd.
sample is not an opinion.
Their work.
That's a test result.
Absolutely not.
But all the
You're-
standards and all the steps that were taken to get that retest results are work product, part of the ultimate result. And that's what, when you ruled last time, you told them, you preserve half of it. So
Yeah,
there's
but
available and they can
no,
run
that
the
was
same
just for
test.
the evidentiary preservation. I've still had the briefing coming in on the cell phone.
No, the
Screen
briefing was
stuff.
concluded long before the last special master
But
hearing.
no, but
Floyd.
I didn't rule on, and I am having a problem with it because having done defense work for 30 years, there were things you didn't want to find out, but you looked into, and once you found it, you had an obligation to reveal it.
Find-
Yes, and they have clean water. They have.
don't find
produced-
anything.
What did
that
I
helps
do?
us.
What did I do the moment we found vanadium? I told
Well-
you about it, okay? I told you about it. I didn't play hide the ball. I tried to move things forward.
But vanadium is found generally in titanium regardless. It is expected to be found.
Vanadium's not expected to be found in titanium.
That I don't know.
Well, if
Well,
nothing else,
I'll
Floyd,
go back over the briefing, but having been in your position many times and felt the obligation, once I found a fact that was damaging to me, I had the duty to produce it. I'll go back over that briefing again, and what I ruled on in the last hearing was everything's got to be preserved so that if I do require you to produce it, they can verify your results or question your results.
and that's exactly what this says. This says we have to tell them what water we tested, and we have to preserve a sample. And if they want to test the same water, they can test the same water. They'll presumably get the same.
Yeah, nobody disputed that.
They'll
Nobody.
presumably get the same facts.
Well.
But what
and
we
now-
don't have to tell them is what tests we did and what we looked for and who it was and why we thought it was important. That's deliberation. That's work product. That's what you're obligated to protect.
I just have to tell you, I've done a million special master hearings, all the way down from the endoscopy cases and everything else. And unfortunately, as a defense attorney, when you find a fact, regardless how you found it, that's relevant, even if it's damaging to your client, you have a duty to produce it. I think you may, you don't agree with that.
I don't at all.
You're
Consultants.
practicing in 1965. I mean, I started in 74, so it was this way when I started. You can't hide facts in litigation anymore because the judges want you to reveal it so that all the facts come out.
Floyd, in every case, you can hire a consultant to do work product testing, and those results remain.
No, you
confidential.
can hire a consultant. You can hire a consultant to give you an opinion. But if a consultant runs a test on the water and finds something, That's a fact that's been discovered.
We fundamentally disagree, Floyd, but if that's
Yeah,
the
we do.
ruling, I'd ask you to put it in an order so that a judge can rule on it.
All right. Okay, what else do we need to cover today?
One was just
Item
kind of
one.
request for information.
No, weren't we on 10?
Yeah,
12,
no,
10?
we're on one.
Yeah.
We skipped one and went
Should
to
be a
10.
quickie.
Hang on, let me get back to mine. Check this. Mine and the other one. No, item one is the titanium tubes, status of the titanium tubes.
Yeah, remember last time we had 2 tubes in the warehouse. So
Yeah, we're missing tubes. Joel, did you find the tubes?
I did not find the tubes. I've confirmed with one of my clients that there's no more tubes that he is aware of. And I am waiting to hear from the other client who happened to be out of the country and he was unavailable when I was trying to reach him. Believe he will be back shortly, but that's just based on what the first client told me. So there's no other tubes that I'm aware of. And as far as the deposition goes, it may be one person that covers both topics, and I'm working on dates.
How many tubes are there?
There are 2 that have been recovered. We think that, when I say we, Real Water thinks that the FDA took some of the tubes, and John Marlowe testified originally there were 12 tubes.
We only have 2 left.
We have 2 that have been accounted for so far.
Can we, what is the status of the FDA? Did they have a report or list of their evidence?
They have produced reports. They have said they will release water to me. They haven't told me that they have other physical evidence, but they did take physical evidence.
So that's federal. Can we depose them?
I'm just going to do a request and see what I get.
Yeah, because when you serve them with a state court subpoena, they laugh.
Yeah, I
Federal
would
government
suspect so.
laughs.
back to the tubes though.
Yeah.
Last time we were here, you thought there were more tubes.
Last time I thought he had produced 3, and then I got the photos from your office where it was only 2 in there. It was we picked those up from the Real Water Henderson warehouse. They were wrapped. Those came from Brent Jones. He put them at the warehouse, and then your office picked them up. I thought that he thought there was 3 in there. I thought there was 3 in there. There was only 2 in there.
Okay. So, and then the FDA took some tubes.
He thinks that.
Isn't there a list somewhere of what was provided to the FDA?
There's a handwritten list that we have produced as to what they think they took, and tubes wasn't listed on that handwritten
Okay,
list.
that's just what I was
But
gonna
the
get to.
report doesn't, that's what I was asking about the report. The report doesn't have like an appendix or an exhibit.
Not that I have seen.
Yeah, we're just starting.
Can you, but it was your client's property, right?
Yeah, right.
There is a
Have
federal
you-
regulation that allows you to,
Yeah, that's what I was
Right.
gonna say. You should at least be able to write them and ask them.
And that's,
But I don't know that we can depose them. I just don't know.
yeah, I don't know about that, but that is what the next step is. We're gonna ask them for a return of the water samples that they took, that they acknowledge that they took, and any other physical evidence. And then second half of that is, I think the person who's gonna talk about the manufacturing process will be the same person on the tubes. And so when that deposition happens, we'll get an answer.
What, how did they take this property? Was your client present?
No, so the FDA showed up to the Mesa warehouse, I believe it was unannounced, and took things, and then they came back, and at the time they were there, Blaine Jones was not at the warehouse, and then they came back a second time, and Blaine Jones was there. And I believe that's how he'll testify. I'm trying to firm that up. So bottom line, I agree.
Yeah, but he
We need
knows
to
how many
produce
tubes he had before and he knows what's left, right?
somebody-
He didn't know he had 12 tubes?
No, because my understanding of the testimony will be that as tubes wore out, John Marlowe took them back. And John Marlowe, during the first couple of years of the operation, came and visited the production line,
Who's Marlowe?
the inventor.
Of the tubes?
Of the tubes, well, not exactly, but he provided the tubes and the
process.
process.
I
No, he
see.
didn't provide the tubes. He said a Russian gave him the tubes. We took
That's
his
correct.
deposition.
I agree with what you said.
Yeah.
Oh, this gets better. You should have told me that before.
No, Judge.
I'm trying to make it short.
Judge
Will wants to tell you the whole
Gonzalez
story.
allowed him to take his deposition, so we took his deposition because he's relatively old. I think he was 78 or something like that.
Careful.
Okay, he was young. So we took his deposition, and he said that he got these tubes, I think he said in the 80s, I'd have to go back and look, but he said a long time ago he got the tubes from some Russian. And Russian gave him 10 or 12. I can't remember the exact number was really put in there.
But we have two of them.
And we have 2 of them,
They're all identical anyway, right? We think.
you know? We don't, I'm
And
sure if
I'm
there's
sorry,
a
Joel,
name these two, they won't be identical.
I was trying to make this story shorter, but Will's right.
Did you,
That's a summary.
did the two that we have come from Mesa, did you tell me?
That is something I should be able to confirm. I don't know off the
No, it
top of
doesn't
my head.
matter. I just-
I don't know.
I thought the 2 tubes we had came from Henderson.
They were delivered to the Henderson warehouse, but I don't know where they originally were, but I can easily find that
Okay.
out.
Well, anyway, I think this kind of highlights the need to do this PMK deposition sooner as opposed to later, so we can get some answers to these things.
Working on dates.
How about the real water computer hard drive?
So I had a meeting with Hollow, and some of the materials are QuickBooks files, and we are trying to get the password for those so those can be produced. I'm sure everybody's going to want that information, and we should have that shortly. I also went over the documents that Hollow has scanned. They have scanned about half of the information, and they've got 62,000 files, not pages, files.
Half of the hard drive?
No, this includes the hard drive, is in that 62,000. We're trying to produce the hard drive, the QuickBooks, and
You guys produced stuff already. How much have you produced now?
the 42,000 documents roughly,
And how many more do you think are coming?
130,000.
In that
These are all off the hard drive?
No, this is everything. This is the entire universe of
hard
documents,
and hard drive?
Files or pages, 130,000.
not pages, documents. So let me start over just to try and answer everybody's questions. There are QuickBooks files.
Sure.
Those are being produced as soon as we get the password. Should have that shortly. There is a hard drive that contains materials other than the QuickBooks files. Those are being sorted by our paralegals and will be produced shortly. There's not that much of it, but there is a lot. There's a lot in
It's easy for you to
in
say.
a construction
you're not
defect
paralegal
case.
reviewing it.
I have 4 paralegals now working on it. Beyond that, there is files from Mesa that are huge. Those are being produced newest to oldest because we figure everybody's going to want the newer stuff and nobody's going to care about the 2005 records.
Are those included in this 42,130?
So the universe of documents I'm talking about right now is in the 62,000 that's been scanned so far, and another 62,000 is on it, Hollow to go.
And that's all of it?
That should be everything. So it's all technically in one toolbox scan. He is scanning it, and I asked him when will he be done scanning everything.
But so what we got now is Henderson.
All of Henderson's been produced, and hard drive is coming next. John thinks he'll have everything scanned, this is just John, in 6 to 8 weeks, and then my paralegal still would have to finish reviewing it.
Maybe you know this, but given that Mesa was relatively new, why is there so much more stuff at Mesa than there was at Henderson?
So Mesa got all of the records for the company from
Henderson?
when it was on Desert Inn.
So all the DI records went to Mesa.
Correct.
The records in Henderson are new Henderson?
Seems to be.
Okay. Okay.
Okay, hang on a minute.
And the purchase orders would be in the Henderson ones, do you think?
I think purchase information is going to be on the QuickBooks files. That's what I'm hoping for.
QuickBooks purchase. Okay.
All right, and the hearing in the Gallagher motion for expedited trial is November 30.
Correct.
Is that Judge Kishner?
Judge Williams.
Tim Williams?
Yeah.
You want me to ask him about it? I'm meeting with him right after our meeting's over. No, I won't talk to him about it. I'm trying to recruit him to jams.
Well, don't do it till next year.
I don't know when he retires. Yeah, it would be whenever he's set to retire.
Well, we heard from, I guess I shouldn't say who we heard But we heard that the thought is that he's gonna run out his term through business court, whatever that runs through, what was it, 24?
He's not business court anymore, is he, in the
No,
Kishner?
he's business.
Oh, he's still business court?
Yeah. He's
Oh,
business
I didn't
court,
know he was still
Kishner.
doing business court.
So anyway, what we heard is that he's gonna finish his term, that Denton's gonna finish his term, and that, who's the third one? Judge Alf?
Johnson?
No, I think it was Judge Alf was gonna finish their terms, and then they were probably gonna retire. So they were thinking there's gonna be 3 business courts.
These people are all younger than me, you know. They're all retiring.
I know.
Well, retiring from the bench.
For you.
Yeah, retire from the bench.
Campaign.
The difference between the people that work for JAMS that are judges are retired and me is that I have to come to work to get paid. Public employees get paid after retirement.
Sorry. Yeah, I think we cover everything.
The insurance policies, you folks are working on that
Yeah.
down in
Nick
Milwaukee.
Castillo, we haven't set her.
What about the Jason Brown depot?
That is the Milwaukee person that we've asked for a date for.
Okay, he said he was working on that.
Yeah, we're ready to depose him. I'd like to do it before Thanksgiving. Or I mean, before.
Have you guys argued this Castillo thing in front of Kishner?
No.
It came up.
Yeah, because she asked me about
Yeah.
it.
It's a long story. We can talk about it after. It's not relevant for today.
What's going on with Miss Castillo?
She's just going to be held in abeyance till we get a couple more real water documents.
Okay.
I mean, I don't, you know, again, like I said before, I don't think she's going to say anything revelatory, but got to start.
No, I know. The concentrate testing is your testing?
Yeah, we've been communicating with our expert as recently as this morning, and we're just trying to get a lab that can do one little other thing that we want to do.
Is this going on in Reno?
Well, we've just been informed maybe we can do it here in Vegas.
Please tell me there's not something they can do in Reno that we can't do here.
Well, there is the Mackey School of Mines in Reno.
That was fantastic.
You got the Howard Hughes Engineering School here, though. I have to tell you, having served on the Board of Bar Examiners for 22 years, the people in Reno think we're part of LA. We always had to have the exact right number of members from Northern Nevada and Southern Nevada. The people from Southern Nevada didn't really care.
But anyway, I think, you know, I was hoping we would file the notice before today, but I'm hoping to get it filed in the next 10 days.
Okay. All right, Joel, when do you guys want me to meet again?
So I would say if we can work out the CMO before we see Judge Kishner on December 5th, we don't need to meet before then. If we can't work that out, then we should meet before then.
Okay.
So maybe we just meet after this, talk real quick, and then.
Well, just
send an
email me the
email
minute
around.
you need a hearing. Even if we have to do it by Zoom or by phone, I can squeeze one in.
Yeah, we may have to. I want to show up show up at the Judge Kishner cases with the CMO.
I'm going to be busy for next week. I'm conducting a qualitative analysis on some real water.
You can test for calcium?
Yeah. Do I have to produce that if I run that test?
No.
When are we supposed to be printing just?
If they have it in.
December 5th.
Maybe we
I'm gonna
should
use it.
kind of tentatively back here.
Yeah, that'd be fine with me.
Okay, November 30th.
You want to have a hearing on November 30? I'll check my calendar. I'll set it then if,
Well, you know, yeah, we'll have the result from Judge Williams probably, because he'll be warning them.
I am not going to mention this case to Judge Williams. I mediated his last case on the Friday before he took the bench on Monday. And I can't remember how far apart we were. I remember the case, I'm arguing with the insurance company, I'm the mediator, and you're like 20 grand. Just, we're not going to pay that extra amount. And I said, let me just put it this way. He's going to be on the bench Monday. And she said, that's not fair. I said, it's mediation. So she paid it. He didn't authorize that. I did that on my own. All right, well, you want me to think about set a hearing on the 30th?
Afternoon.
In the afternoon, and if for some reason, because of your schedule, what's going on, if you tell me, all you have to do is email me and say, no, we need it delayed a week or whatever it is.
Okay. Sounds good.
right, I've got to. Hang on, let me give me a minute to go through what I had questions from the last time. I thought I had one of the things covered. Just give me 1 second here. Oh, how are the subdirectories going? Did that get done on the PI cases?
Yep.
Okay, good job.
Any problems or no?
No,
This is okay.
yeah, and there was some confusion about access for the real water documents. That's been solved.
Okay, no, that's fine. All right, so I'll see if we can set a hearing on the 30th. If I have something else, I can probably move it. And I'll get out a notice on that and we'll do it in the afternoon.
Thanks.
Thank you. All right, you folks on the participating by Zoom, you're all muted anyway, but do you need us to cover anything else before we cut off today? Jim says I've done enough damage. I'm going to go back and read your Davidson case or whatever it is. and the
Yeah,
other
please.
two cases.
Thank you, Mr.
Well,
Hale. I
I'm
appreciate
going to
it.
read it. I'll probably let you argue it again anyway.
Well-
Besides any ruling I do that anything is like that, I usually remember to put in the order that if somebody objects, that the order is stayed until a district court determines the result. You don't have to file motions to stay with me. Usually on something I know that's contested, I put one of the paragraphs in the order is if there's a timely objection, the enforcement is stayed until, until the court rules. So, all right, I think we're done. Thanks, everyone.
Thank you.
Thank you.